I'd like to talk about another trap that can occur with ERISA cases. This trap is new evidence considered on a final appeal. Talk about unfair. You see, the way the ERISA claim process works is you file your claim, and the insurance company considers that claim, and they may ask nurses or doctors to review the information to see if paying the claim is warranted under the plan terms or not. And then if you get a denial, you're supposed to give specific reasons why your claim has been denied, and then you have the right to obtain the claim record. And so you can obtain that, and then you can notice perhaps that the reasons why the claim has been denied are all wrong, and you can prove it. And so then you set about to prove and obtain all of the evidence that is necessary to win your case. You obtain statements from your treating doctors, you obtain information pointing out that the person who denied the claim misunderstood information. Perhaps you get statements from coworkers. If you're an attorney, you're going to have access to experts, expert testimony such as vocational experts, and you may have testimony from an independent physician. And so there's some things that can be done to challenge that decision and point out why it is wrong. And so you submit that. But then you know what happens on appeal? The insurance company or the plan administrator or claims administrator looks at that and they say, they have a point there. They may be right. And so then they develop a new and different reason to deny the claim that you've never seen and you have never had the opportunity to address. And so the claim is then denied again. And they tell you, hey, it's time for you to go ahead and file a lawsuit if that's what you want to do. We're not going to listen anymore to anything you have to say about this claim. Take it to the court if you want. And so you receive that claim denial letter, and it's a little vague and ambiguous, and then maybe you take my advice and you obtain that final claim record, and then you see that they have done some things in there to generate an entirely new decision on their final appeal. That's not fair, and that's a trap for the unwary. And so it's important to have experienced ERISA counsel so that you can take action during the claim process to point out these are the only reasons why the claim has been denied. And if there's a new reason generated, I demand the right to be able to respond to any new evidence considered or any new reasons to deny that claim. We call that a post hoc rationale, a rationale generated after the fact. And what happens with this trap is there's no meaningful exchange of information, which is a failure to provide a full and fair review. That is not a trap you want to get caught in, because if you go to court without trying to rectify that trap, at best the judge may require the case to be remanded back to the insurance company. At worst, the judge is going to say, well, you should have done something about that before you filed suit. I have to go ahead and give deference to their decision, and so I'm denying your claim. Not a good place to be. So you want to try to do everything you can to remedy staying out of that trap. You need experienced ERISA counsel on ERISA cases. Thanks.